Cypress Falls, Louisiana, there's a particular kind of trust that exists between a dying person and the doctor who tends them, a trust built on vulnerabilities so total and so one-sided that it can barely be described as a relationship at all in the ordinary sense. The dying person hands over everything, their body, their fear, their last weeks, and the doctor's obligation in return is the most fundamental one medicine has ever produced: to ease suffering without hastening its end. For 22 years, the people of Cypress Falls believed that a man named Dr. Aldous Mercer held that obligation more seriously than almost anyone they had ever known. He worked late. He remembered the names of his patients' grandchildren. He sat at bedsides after his shift ended and held hands in the dark. He was, by the time the truth finally came apart at the seams in the spring of 2023, the most beloved figure in a town of 4,000 people, and he had been quietly ending lives one careful milligram at a time. Since the spring of 2001, the investigation that eventually undid him started not with a police tip or a suspicious family member, but with a spreadsheet. Lucinda Garza was a hospice intake coordinator at Cypress Falls Memorial who had worked the same desk for 14 years and who had a habit born from professional conscientiousness rather than any suspicion of tracking her patients' admission to death intervals in a personal spreadsheet she kept on her home computer, a way of monitoring her own caseload and identifying patterns in care quality. She had started the spreadsheet in 2009 for reasons she described as mundane, and by early 2022 it contained records on 412 patients. She wasn't looking for anything when she found what she found. She was simply doing a routine year-end review, and something jumped off the screen that she couldn't explain and couldn't stop looking at. Patients admitted to the hospice's Eastern Wing, the one under Dr. Mercer's primary care, were dying at a rate statistically distinguishable from patients in every other wing. Not dramatically faster in a way anyone would have caught on instinct alone, but measurably, consistently faster when the numbers were laid out side by side. The difference averaged out to 11 days. 11 days fewer of life on a patient population that otherwise looked demographically identical to the rest of the facility's intake. Lucinda spent 2 months rechecking her math, convinced she'd made an error. She hadn't. She then spent another 3 months not telling anyone because what she was looking at could not be true. Aldous Mercer had personally recruited her to Cypress Falls Memorial. He had written her a letter of reference. He attended her daughter's Quincy era. She finally called the Louisiana Department of Health's anonymous tip line on a Tuesday morning in November of 2022 while sitting in her car in the hospital parking garage, as far from her desk and her colleagues and her own guilt as she could get within walking distance of the building. She told the intake worker she probably had bad numbers and was probably wasting their time, but that she needed someone else to look. The investigator who picked up the referral was a state healthcare fraud analyst named Bernard Tate, whose usual caseload involved billing irregularities and Medicare overclaims, of case whose implications he immediately understood were going to be unlike anything he'd worked before. He called Lucinda back 2 days later, asked her to send the spreadsheet, and then spent a very quiet weekend in his home office going through 412 patient records against her data. By Sunday night, he had called his supervisor. By the following Thursday, the Louisiana Attorney General's office had a case file. What Bernard Tate and the team that assembled around him over the following months discovered was a pattern that became more damning the further back it was traced. And the further back it went, the harder it became to believe that anyone had ever missed it, until the investigation produced the explanation for why no one A nurse had seen it a decade earlier and tried to stop it, and had been not only disbelieved but professionally destroyed for the attempt. Her name was Patricia Odom. She had worked the eastern wing of Cypress Falls Memorial from 2006 until 2012, and in the winter of 2011 she had brought to the hospital's chief of medicine, a man named Dr. Robert Hearn, a concern almost identical to the one Lucinda Garza would raise 11 years later, that patients under Mercer's primary care seemed to reach the end of their lives faster than expected, even given their admission diagnoses. Patricia had no spreadsheet, only clinical instinct built from 6 years of intimate proximity to dying people, and the response she received from Dr. Hearn was swift and definitive. She was told, politely but unmistakably, that hospice care involved a great deal of clinical nuance, that an intake nurse was not positioned to second-guess, that end-of-life's trajectories were highly variable, and that raising unfounded accusations against a physician of Dr. Mercer's standing and care record was a serious matter that reflected poorly on her own professional judgment. Patricia was placed on a performance improvement plan 3 weeks later for reasons unrelated to her complaint, and she resigned before the plan was completed. She spent the next decade working in a pediatric clinic in Shreveport, and she did not speak Aldous Mercer's name until a state investigator sat across from her in a conference room in 2023 and showed her a case file with her own complaint letter attached as the first exhibit. The investigation, the clinical evidence, once investigators had authorization to examine Mercer's records in full, was more extensive and more careful than Bernard Tate's team initially anticipated. Mercer had not been reckless. He had not left obvious fingerprints in the dosing records, had not dramatically exceeded standard pain management protocols in any single case, had not done anything that any individual attending physician reviewing a single chart would have flagged as unusual. What he had done, across more than 2 decades, was operate at the outermost edge of clinical permissibility in every case, making cumulative adjustments to sedation and pain management regimens that were each individually defensible and collectively, over time, produced outcomes differed from the statistical baseline in a way that only became visible when hundreds of records were examined at once. The investigators brought in 2 independent clinical pharmacologists to review the records, neither of whom was told the other's conclusions until both had delivered their reports. Both identified the same pattern independently: morphine and midazolam adjustments in the final 48 to 72 hours of a patient's care that were consistently at the higher end of dosing ranges, combined with a reduction in stimulant nutrition interventions that the clinical notes justified with language about patient comfort and family wishes. Each decision in isolation was defensible. Together, they described something the pharmacologists both called, in the careful language of expert witnesses who understand that courts need precision, a systematic pattern of care decisions inconsistent with life-prolonging intent in a population where prolonging life remained a clinically viable option. That last phrase, clinically viable option, became the hinge of the legal case. Mercer's defense, when the arrest finally came in September of 2023, rested almost entirely on the argument that his patients had been dying anyway, that accelerating the end of a terminal patient's life by days or weeks in the context of unbearable suffering was a clinical judgment call well within the accepted norms of palliative care, and that the line between adequate comfort care and euthanasia was a philosophical and legal fiction with no reliable clinical definition. His attorney was good, and the argument was not frivolous. Louisiana law on end-of-life dosing was not as clear as the prosecution would have preferred, and the first 2 weeks of trial were markedly uncomfortable for the state's case. What broke the defense open was not clinical evidence at all. It was a letter. Among Mercer's personal papers seized from his home office during a search in October, of 2023 was a private correspondence file that contained, among other things, a series of letters exchanged over a period of roughly 8 years between Mercer and a retired physician named Calvin Price, who had been a mentor of his during his residency in the 1990s and who had died in 2018. The letters were not, on their face, confessions. They were the correspondence of two intellectually serious men discussing a philosophy of death and medicine that Mercer and Price both clearly believed in deeply and had developed together over decades. A philosophy they called, in their private letters, release medicine, held that a doctor's highest obligation was not to the life of a patient, but to the quality of the consciousness ending, and that a physician of sufficient moral courage ought to act on that obligation regardless of what the law permitted. The letters did not provide direct clinical admissions. They did not say, "I gave patient A a lethal dose on date B." What they provided was something prosecutors sometimes find more valuable than a direct admission: a documented intellectual framework through which a man had spent 20 years justifying to himself and to one trusted confidant exactly the thing the clinical evidence said he they described a kind of certainty that makes a person not reckless but patient, not wild but systematic, not afraid but entirely completely convinced that he was right. The jury read those letters over 2 days of testimony. They deliberated for 9 hours. The families what the guilty verdict on 11 counts of second-degree homicide, with sentencing pending on an additional 7 counts whose cases were still being fully prepared, could not do was answer the question that moved through Cypress Falls in the months before, and after the trial light weather nobody could quite get ahead of. How many? The state's charge of 11 represented cases where the clinical evidence crossed the threshold. The prosecutors believed they could prove beyond reasonable doubt. The pharmacologist's review had identified potential concerns across more than 40 patients. The patient population Mercer had cared for over 22 years numbered in the hundreds. The gap between 11 proven cases and the larger number implied by the pattern was a gap that the law had a very limited ability to close, and that the families of Mercer's former patients had to live inside. Cypress Falls Memorial had approximately 4,000 former patients who had passed through its hospice during Mercer's tenure. Of those, the majority had died in the ordinary, devastating, expected way that hospice patients die, and their families had nothing to look at their grief through but grief. But for a significant and unknowable fraction of those families, the question that had now been put in front of them by a criminal verdict was whether the man who had sat at their mother's bedside, who had remembered their children's names, who had held hands in the dark, had been doing something to hasten and that might otherwise have come 3 weeks later, or 5 weeks, or 2 months. Some of those families told investigators they didn't want to know. Some said they did want to know and were told honestly that there was no way to be certain. A woman named Elaine Duplessis, whose father had died in Mercer's care in 2014, told a reporter from the Baton Rouge Advocate that she had spent weeks trying to remember every conversation she'd ever had with Mercer about her father's care, looking for something she should have caught that she hadn't, before finally deciding that the guilt was misdirected. "He was the doctor," she said. "That's the whole point. We trusted him because he was supposed to be the one who knew. That's what a doctor is. That's what makes this what it is." Patricia Odom testified at sentencing. She read a prepared statement in which she described in careful clinical language what the winter of 2011 had cost her, the position, the patients she'd known, the years in which she had carried a half-extinguished suspicion that something had been wrong. and a fully alive conviction that she had failed the people who couldn't speak for themselves. She said she did not want gratitude and she was not there for vindication. She said she was there because she believed that the record should contain her name alongside Mercer's, not as an accomplice but as a witness who had existed 11 years earlier and had not been powerful enough or believed enough or protected enough to do anything useful with what she saw. She said that seemed to her like information a future hospital board might need. Aldous Mercer was sentenced in the spring of 2024 to 11 consecutive life terms, with the additional 7 charges resolved through a plea agreement that added no practical time to his sentence but produced, at the prosecution's insistence, a formal detailed admission of methodology for each of the 7 cases, a record intended not for legal purposes but for the families who had been told they would have the truth of how it had happened, even if the courtroom could not give them certainty about whether it had happened to their particular person. He was 67 at sentencing, composed in a way that the courtroom found unsettling, and that his former colleagues described in the weeks afterward as consistent with the man they had known, a person so certain of his own moral framework that the law's disagreement with it registered to him as the law's problem rather than his. He made no statement and requested no leniency. He acknowledged the court with a nod that his attorney later called respectful and that every family member in the gallery described differently. Lucinda Garza was placed on administrative leave during the investigation and reinstated with a formal apology from the hospital's board after the trial, along with a recommendation that her approach to data monitoring be adopted as standard procedure across the facility's care wings. She told the board politely that she appreciated the recommendation and then requested and granted a transfer to the hospital's administrative offices where she has worked since, in a position that does not involve direct patient-family contact. She still maintains the spreadsheet. She has told colleagues it is a habit she does not expect to break. The hospice at Cypress Falls Memorial was restructured in the aftermath of the case. Its patient care protocols revised to include mandatory secondary review of all pain management escalations in the final 72 hours of a patient's life, a change that the hospital's new chief of medicine described in a public statement as standard best practice, which was both true and a careful way of avoiding the question of why it had not been standard practice for the previous 22 years. The Eastern Wing was renumbered. The photograph of Aldous Mercer that had hung in the facility's lobby, next to the photographs of 3 other physicians recognized for long service, was removed without ceremony or announcement the week after the arrest, and nobody who worked there brought it up, and nobody asked why it was gone. The bench outside the hospice entrance, the one with a small plaque dedicating it to Dr. Mercer's decades of service, stayed in place longer, an oversight rather than a decision, and was quietly unbolted and replaced with an unmarked bench in the early months of 2024, a change so minor and so carefully undramatic that most patients' families visiting the facility never noticed, and that the small number who did notice chose, for the most part, to let pass without comment because there was not, in the end, a good way to mark what had happened there that would not have made the parking lot outside a hospice feel like less of a place where people could bring themselves to go. The town held 2 memorial services in the year after the verdict, one organized by a patients' rights group from New Orleans and attended largely by people from outside Cypress Falls, and one organized by the families of the confirmed victims, small and private, and held at a church on the south end of town. The private service was not covered by any media and none of the attending families spoke publicly about what happened there. What is known is that Patricia Odom attended, and that she sat in the back row, and that after the service she spoke privately for a long time in the church parking lot with Elaine Duplessis, whose father had died in Mercer's care in 2014, and that neither woman has described publicly what they said to each other, which is, by every measure that matters, exactly as it should be. Cypress Falls Memorial Hospital is still open. It serves the same 4 counties it has always served, the same patchwork of small towns and rural parishes that have always had no other reasonable option for serious medical care within an hour's drive. People still bring their dying relatives there. They still sit in the same waiting room and speak to doctors and nurses, who have, in most cases, spent their careers trying to do the right and careful thing in a job that is hard and undercompensated and emotionally brutal in a way that most people on the outside never fully reckon with until they find themselves on the inside needing it. The hospice is not a place of fear any longer, at least not in the specific way it was, though it is now a place where a different kind of attention is paid, a counting and a checking and a cross-referencing that did not exist before, put there by a woman who sat in a parking garage and made a phone call because the numbers on her home computer would not let her sleep. That attention is, by any clinical measure, a good thing. It costs the facility a small amount of administrative time, and it catches, now and then, a dosing irregularity that might otherwise have gone unreviewed, and in every case examined since the new protocols went into effect, it has turned out to be exactly what a dosing irregularity in a hospice usually is: a miscalculation, a charting error, a judgment call that a second set of eyes gently corrected. Nothing sinister, nothing like what came before, just the ordinary imperfect machinery of medicine trying to do its best, monitored now by a system that understands in a way it did not understand before, that trust and accountability are not opposites, and that the most dangerous space in any institution is the one that everybody agrees is too sacred to look at carefully. The second case, the investigation into Aldous Mercer, had barely entered its trial phase when a parallel development, unconnected to Cypress Falls in any direct way but eerily resonant in its structure, began to unspool some 900 miles north. In Granger Falls, Ohio, a town of 6,000 and a county that had been losing population steadily since the 70s, a hospice administrator named Chester Mould was arrested in December of 2023 on charges unrelated, at first, to anything like what was happening in Louisiana. He had been caught, initially, in a financial fraud investigation, skimming from the facility's operating budget through a series of small, incremental invoice manipulations that the facility's new external auditor caught during a routine review. It was small-time fraud by the standards of financial crime, and Chester Mould, 61 years old and 2 years from retirement, might have faced a fine and probation, and the quiet end of a 30-year administrative career, and nothing more, except that the auditor who caught the financial irregularities, a meticulous woman named Sandra Cho, had a secondary habit that Chester had never anticipated. She cross-referenced financial anomalies against operational records as a matter of routine, looking for the story that the numbers were telling under the story the numbers claimed to be telling. What Sandra found, buried 3 layers deep in a supply procurement trail, was a pattern of pharmaceutical ordering that did not match patient census records in a way she could reconcile. The hospice was consistently ordering significantly more of two specific medications, both used in end-of-life sedation protocols, than its average patient population and length of stay numbers could account at standard dosing rates. The discrepancy was not enormous. It was not the kind of number that screamed. It was the kind of number that whispered persistently over a span of 7 years of procurement records. Somewhere between what was being ordered and what clinical records showed being used, a quantity of medication was disappearing into a gap that the paperwork did not explain. Sandra flagged it for the Ohio Department of Health. It took 11 months, 2 failed attempts to get clinical record access, and a court order to finally open the patient files. By the time the picture came into focus, investigators had identified a physician named Dr. Frank Loring, who had served as the facility's medical director since 2016, as the central figure in what the prosecution would eventually describe as a systematic misallocation of sedation medications toward outcomes inconsistent with the clinical pattern standards. When it was finally mapped by a team that included 3 of the pharmacologists who had worked the Mercer case in Louisiana, was different in its details but similar enough in its structure to raise a question that nobody involved in either investigation wanted to say out loud, but that the record eventually forced into the open. Had these 2 men known each other? The connection. Aldous Mercer and Frank Loring had completed their residencies at the same teaching hospital in Memphis in the early 1990s. They had not, as far as investigators could establish, worked together clinically or maintained any direct professional relationship in the decades since, but they had both attended a small invitation-only continuing medical education symposium in 2003, palliative focused on end-of-life pain management, list and when subpoenaed and reviewed contained 41 physicians, the majority of whom had entirely conventional careers in palliative medicine, and 2 of whom were now facing criminal charges for the same category of offense. The conference itself was not a criminal enterprise. Investigators reviewed the recorded proceedings and found nothing more than the ordinary, earnest, sometimes philosophically contentious debates that mark serious academic medicine's ongoing argument with itself about where care ends and something else begins. But buried in the conference materials in a supplementary reading list distributed to attendees was a paper authored by a retired physician named Calvin Price, published in a small fringe medical ethics journal in 2001 and given almost no attention in the mainstream medical community. Its title was The Physician as Final Advocate, a Case for Release Medicine in Terminal Care, and its central argument held that a physician of sufficient moral conviction was not only permitted but obligated to act as the final advocate for a dying patient's release from suffering, regardless of what the law's boundaries permitted, because those boundaries had been drawn by people who had never sat at a bedside at 3 a.m. and truly understood what relieving suffering required of a person willing to take it seriously. Neither prosecution could prove that either man had been specifically shaped by this paper at that specific conference. But it raised a question the medical ethics community began wrestling with urgently in the months after both cases became public. How many other physicians trained in the same era, shaped by the same increasingly fraught debates about end-of-life autonomy, had a philosophy like Price's and found in it not an intellectual curiosity but a permission they had been waiting to be given? The audit program. The National Association of Hospice and Palliative Care, responding to both cases and to the pressure they generated, announced in the spring of 2024 a voluntary audit program through which member facilities could request independent clinical review of their outcomes data, using the same statistical methodology Lucinda Garza had invented at her kitchen table with a home computer, and a 14-year spreadsheet. The program was voluntary, which meant participation was self-selecting, and the facilities most likely to have something to hide were also the least likely to sign up. 43 facilities enrolled in the first 6 months. 4 of those reviews produced findings that warranted referral to state health authorities. In 2 of those 4 cases, the referrals led to investigations that were still ongoing at the time this file was closed. Nobody in the medical establishment or the legal system was prepared to say those 4 findings represented the full extent of the problem. Nobody was prepared to say how much larger the problem might be, because the honest answer was that the tools to measure it had only just been invented by someone with no official mandate to invent them, working alone without resources, because the numbers on her screen would not let her look away. Bernard Tate, the healthcare fraud analyst who had picked up Lucinda Garza's tip call and spent a weekend going through 412 patient records, was promoted twice in the 18 months after the Mercer verdict and is now the director of Louisiana's newly created Healthcare Outcomes Integrity Unit, a small office with a mandate to do systematically and with proper funding exactly what Lucinda had done at her own initiative and her own desk on her own time. He has said in interviews that he considers her work a gift a medical system did not deserve and badly needed, and that the most important thing his office does is nothing more glamorous than counting carefully and refusing to stop counting. When the numbers become uncomfortable, Frank Loring's case proceeded through the Ohio courts on a parallel track with Mercer's, at a slower pace due to ongoing evidentiary challenges around the pharmaceutical procurement records, and had not reached a verdict at the time this account was compiled. His attorney has argued that his client's clinical decisions fell within the accepted norms of palliative care, and that the statistical pattern identified by the auditors reflected the natural variation inherent in a patient population of that size and complexity. That argument echoed Mercer's defense almost word for word, which was either a coincidence of legal strategy or a reflection of the fact that the line being drawn in both cases was genuinely unclear at its edges in ways that medicine and law had never been forced to agree on before, and that the cases themselves were doing the uncomfortable and necessary work of forcing that agreement into existence for the first time. Lucinda Garza gave one interview to a medical industry trade publication that had asked specifically about the methodology she had used, in which she described the spreadsheet and its 14 years of data in clinical, technical terms, and said almost nothing about herself. At the very end of the interview, the journalist asked her whether she believed she had saved lives. She was quiet for a moment before answering that she thought that was probably the wrong frame. The people already gone were already gone, she said. What she thought she had done, at best, was make it slightly less likely that someone else would go the same way without anyone noticing, which was different from saving lives, and also, she thought, probably the most anyone in her position could honestly claim to have done. The journalist noted that she seemed almost reluctant to accept any credit. Lucinda said that she thought reluctance was appropriate given that she had waited 2 months before making the call, and that the right thing to think about was not how she had eventually done the right thing, but why it had taken 11 years for someone with the right combination of data access, professional position, and willingness to look to come along at all, and what that said about every institution's tendency to protect its own reputation more carefully than it protects the people most completely in its care. Cypress Falls Memorial Hospital is still open. It serves the same 4 counties it has always served, the same patchwork of Small towns and rural parishes that have always had no other reasonable option for serious medical care within an hour's drive. People still bring their dying relatives there. They still sit in the same waiting rooms and speak to doctors and nurses, who have, in most cases, spent their careers trying to do the right and careful thing in a job that is hard and undercompensated and emotionally brutal in a way most people on the outside do not fully reckon with until they find themselves on the inside needing it. The hospice is not a place of fear any longer, at least not in the specific way it was, though it is now a place where a different kind of attention is paid, a counting and a checking and a cross-referencing that did not exist before, installed there by a woman who sat in a park-in garage and made a phone call because the numbers on her home computer would not let her sleep. That attention is, by any clinical measure, a good thing, and on most days, it is exactly that and nothing more, a system doing what systems are meant to do, catching ordinary errors before they compound, confirming that ordinary care is ordinary, making the people inside feel rightly that someone is watching. Most days the numbers add up the way numbers are supposed to add up. And the gap between what was ordered and what was used closes cleanly, and the interval between admission and death falls exactly where it should, and the Eastern Wing looks from the outside and from the inside like what it has always wanted to be, a place where people are carried gently toward an ending they cannot avoid by people who have chosen, of their own free will, to sit with them in the hardest part of a life and help them through it. Most days it is exactly that. The new protocols make sure someone checks. That is the difference between most days now and most days before. It is a small difference and a very large one, and it was bought at a price that Cyprus Falls is still, and will be for a long time, in the process of calculating. The nurses who stayed. Any honest account of what happened at Cyprus Falls Memorial has to include the people who kept working there after the arrest, after the trial, after the verdict, because the facility didn't close and the patients didn't stop needing care, and someone had to stay. Most of the hospice staff did stay through a period that can only be described as professionally and emotionally catastrophic, a period in which they came to work every day in a building that was simultaneously a functioning medical facility and a crime scene that the media had decided was the most important story in the state of Louisiana, and they answered patient call buttons and changed dressings and sat at bedsides and did all the things they'd always done while their faces appeared in the backgrounds of television news reports and their names were occasionally spelled wrong in newspaper accounts, and their professional community looked at them sometimes with an expression they couldn't quite categorize and hadn't asked to earn. A charge nurse named Vera Simmons had worked the Eastern Wing for 11 years. When Mercer was arrested, she had been Patricia Odom's colleague and later a colleague of the nurses who replaced Patricia after she left, and she told a hospital task force in 2024 that she had spent 11 years believing she was a good nurse in a good unit, and that the verdict had not changed that assessment but had layered something complicated and unresolvable on top of it that she was still working through. She said she had reviewed in the weeks after the arrest every patient death. She personally remembered from Mercer's care every family she had sat with, every moment she could reconstruct of those final hours, looking for the things she should have seen and had not. She said she found on that review several moments that looked different in retrospect. than they had at the time, and that she could not determine even now whether those moments looked different because they actually were different or because she was looking at them through the lens of a verdict that had told her in advance what to find. That uncertainty, Vera said, was the one that had the longest half-life. Not the guilt exactly, which was considerable, and not the grief, which was also considerable, but the specific epistemic discomfort of no longer being certain whether her own professional memory was trustworthy, whether the clinical instincts she had spent a career building were sound instruments or instruments that had been calibrated in a compromised environment for so long that she could no longer reliably tell the difference between adequate and adequate seeming. She was still working the Eastern Wing when she said this. She expected to keep working it. She said she didn't know what else she would do, and that the honest answer to the question of why she stayed was that the patient still needed someone to stay, and that her uncertainty about her own reliability was not, she believed, a reason to leave them with fewer people than they needed. It was a reason to be checked, and she was being checked, and she thought that was probably as much as any of them could do. The town of Cypress Falls processed the case the way small towns process the discovery that the person at the center of their collective trust has turned out to be something other than what he seemed. Slowly, loudly at first, and then more quietly, in the way that grief eventually goes quiet, not because it is resolved, but because the daily business of being a town does not pause long enough for grief to complete itself on any schedule other than its own. The diner on Pickett Street where Mercer had eaten lunch for 20 years stopped putting his usual table by the window when it became apparent that his face was being photographed through the glass by visiting journalists. The high school where his daughter had graduated and where he had occasionally spoken at career days quietly removed the signed photograph from the counselor's office bulletin board. And nobody mentioned it to the counselor, who noticed and also did not mention it to anyone. The church where he had served as a deacon for a decade held a special session of the Elder Board in January of 2024 to formally address his membership, which was suspended pending appeal and then terminated on the day of sentencing by a 2/3 vote that the church's pastor described in a statement that was painful to read and clearly painful to write as the most solemn business that board had conducted in his tenure. His wife, Deborah Mercer, issued a single brief public statement through an attorney on the day of sentencing, in which she said that she did not believe her husband was the person the verdict described, and that she expected to continue that belief regardless of what further proceedings might occur. She has not commented publicly since. Their daughter has not commented at all. That silence is worth respecting, not because it suggests innocence or guilt of anything, but because the family of a person convicted of serious crimes is not obligated to perform any particular response to that conviction for a public that did not ask them before deciding to consume the story, and the absence of a statement from them should be read as exactly what it is: the absence of a statement, nothing more. Aldous Mercer is imprisoned at a Louisiana State Correctional Facility. He is, by all available accounts, quiet and cooperative, and has enrolled in no programs and requested no special accommodations, and has received exactly one visitor since his incarceration began, a former colleague from his residency years whose name has not been made public and whose visit was brief. He reads, "The facility records indicate he has not spoken to media. He has not appealed his sentence. Whether the absence of an appeal reflects acceptance, calculation, or the particular kind of pride that does not permit a man to let a court revisit the question of whether it was right. Nobody who knows him has been willing to say, and the question sits in the public record exactly where most such questions about the interior lives of people who have done terrible things ultimately sit, unanswered, imperfectly understood, and carrying within it the particular discomfort of an explanation that may exist somewhere, but that no journalist, no investigator, and no family member has yet been able to fully retrieve. The spreadsheet that started everything still exists. Lucinda Garza still updates it. It has grown since the investigation began to include not only the patients she directly tracked, but a secondary column of data drawn from the anonymized outcomes reports, now generated quarterly by the new protocols, a column that does not name anyone and does not accuse anyone and is not evidence of anything except the normal variation of mortality in a population of people who are already dying, charted with a steadiness and a care that is itself a kind of answer to what happened, not a complete answer and not a comfortable one, but the best available answer to the question of what a person does practically and daily once she has learned that the numbers that seem like they are adding up correctly can sometimes, if you watch them long enough and carefully enough, turn out to be telling a story the facility's official record has decided not to tell. She watches them. She will keep watching them. She does not consider this a burden, and she does not consider it heroism. She calls it, when anyone asks, the job. The third case that year. It would be convenient and wrong to treat the Mercer verdict as a closed and singular event, a contained story about one man whose particular pathology produced particular consequences in one particular town. The case did not stay contained, and not only because of the Ohio connection. In the fall of 2024, 3 months after Mercer's sentencing, a hospice in rural Vermont called the Green Valley Care Center came under state scrutiny following an anonymous complaint that bore a structural resemblance to Lucinda Garza's initial tip, which had by then been widely covered in the healthcare press and had given other people with other spreadsheets and other quiet years of accumulating concern a model for how to name what they were looking at and where to take it. The Vermont case was smaller, its confirmed findings covering a shorter period and a narrower patient population, and it involved not a physician but a senior palliative care nurse practitioner named Douglas Vail, who had operated with a level of independent clinical authority unusual for a non-physician, and who had, investigators concluded, used that authority across a 4-year period in a manner consistent with the pattern now being called in the medical and legal literature that was rapidly accumulating around these cases, palliative homicide, a term that had not existed before 2023, and that the medical establishment was still actively debating whether it was precise enough to be useful or imprecise enough to be dangerous. Douglas Vail was arrested in January of 2025 and has maintained, through his attorney, that his actions were entirely within the clinical and ethical framework of compassionate palliative care, and that the evidence against him reflects the same confusion between adequate comfort management and accelerated dying that had characterized both the Louisiana and Ohio cases. Confusion, Vail's attorney argued, was not the product of any criminal intent but of a legal framework that had failed to keep pace with the genuine and urgent and unresolved debates within medicine itself about what the obligation to relieve suffering actually required. It is again not a frivolous argument. It is the argument that the practice of medicine has been having with itself in one form or another for decades, and that these cases have forced into a public and legal arena where its resolution, one way or another, can no longer be deferred to committees and journals and symposia attended by 40 physicians on a reading list that nobody outside the field ever thinks to examine. Bernard Tate, running his Louisiana unit, speaks to counterparts in Ohio and Vermont, and 3 other states now on a weekly call. They share methodology, compare case structures, and occasionally discuss the question that everyone in the network has quietly concluded is the real question underneath all the specific cases, whether what they are identifying is a series of independent actors who each arrived separately and through their own paths at a philosophy that led them in the same direction, or whether there is, somewhere under the surface of palliative medicine's internal argument with itself, a current of belief sufficiently organized and sufficiently widespread to constitute something more like a movement, one that has operated for decades in the particular shelter provided by the combination of clinical complexity, patient vulnerability, and institutional end-of-life medicine at its most serious and its most intimate. He does not know the answer. He suspects he is unlikely to find it in a procurement spreadsheet or a dosing record or a stack of personal letters, and he is increasingly certain that, whatever the answer is, it will require to fully understand a kind of attention to the history and sociology of a profession that neither he nor any other fraud analyst was trained to provide, and that will require the field to look at itself with an honesty that no profession, in his experience, has ever found easy or done willingly, and that will almost certainly have to be imposed from outside rather than generated from within, because that is how institutions work and how they have always worked, and knowing that does not make it any less frustrating or any less necessary or any less urgent for the people who are right now in a bed somewhere, trusting someone to be only what they have claimed to be. The spreadsheet Lucinda Garza keeps is, at its bottom, a document about trust. It trusts the numbers to tell the truth if you look at enough of them for long enough. It trusts the process of counting to eventually produce a count that cannot be rationalized away. It trusts that someone, given a clear enough picture, will do something with it. Those 3 trusts are modest ones, and they have so far been justified imperfectly, and at great cost, and far later than anyone would have wanted. Whether they will continue to be justified in Vermont and in Ohio and in whatever case file is being assembled right now in whichever state has not yet made the call, is a question that belongs to the future and to the people who will, at some desk in some facility in some small town, eventually do what Lucinda Garza did: look at the numbers until the numbers look back, and then pick up the phone. What the record shows. The case file for Louisiana v. Mercer, as formerly archived by the State Attorney General's office, runs to 47 binders. The medical evidence alone constitutes 22 of them. The personal correspondence between Mercer and Calvin Price fills 2.5 binders of its own, 612 pages of letters exchanged across 8 years between 2 intelligent men who believe deeply in something that the law has decided is not a belief anyone is permitted to act on, regardless of how sincerely it is held or how much suffering. In a room at 3 in the morning it was invented to address. Those letters will remain in the state archive for 50 years under standard retention policy. They will outlast Aldous Mercer, who is elderly and imprisoned, and Calvin Price, who is already dead, and the immediate generation of physicians for whom the debates those letters describe were contemporary rather than historical. They will be read eventually by someone trying to understand what medicine believed about itself in the early 21st century, and that reader will find in them something that most crime cases don't produce, which is not the record of a broken person trying to explain a failure, but the record of a very particular kind of certainty, the kind that does not flinch and does not apologize and does not understand itself as wrong, which is in many ways more disturbing than the alternative, because it suggests that the problem it represents is not one that better training or stricter oversight or more transparent dosing protocols can fully address. The answer, if there is one, lies somewhere in the longer and harder and less tractable project of building institutions that do not inadvertently create the conditions which a person can spend 22 years being more trusted than they are checked. In a room where the people most affected by what they do are the least able to say so. That project does not have a completion date. It does not have a clear blueprint. It has at the moment a woman in Cypress Falls who updates a spreadsheet, and a small underfunded state office in Louisiana counting numbers and counterparts in Ohio, and Vermont and 3 other states doing the same, and a voluntary audit program with self-selecting enrollment and a medical ethics community having a debate that has been too long deferred and is now finally, uncomfortably, being conducted in public rather than in journals. That is what there is. It is not enough, and it is more than there was before, and the distance between those two things is the space inside which the next case is. At this moment, already quietly taking shape in a facility whose name nobody outside its county has ever thought to say, tended by a physician who is on every measure that the people around him can see and count and verify exactly what he appears to be. Patricia Odom retired from clinical nursing in the summer of 2025 at 61, earlier than she had planned, but not, she told the colleague who asked, sooner than she was ready. She spent a month at her sister's house in Mississippi and then took a part-time position as a clinical ethics consultant at a teaching hospital in Baton Rouge, a role she had not anticipated and had not applied for, offered to her by a department chair who had read her sentencing statement and concluded correctly that a person who had carried that specific knowledge for that specific length of time, without letting it make her cynical or careless, had something to teach that could not be found in a textbook. She teaches a seminar now, once a semester, on institutional courage and clinical whistleblowing. A seminar that is technically optional and consistently over-enrolled, attended not only by nursing students but by medical residents and hospital administrators who fill the available seats faster. And the department can add them. She does not describe herself as a hero in that seminar, and she stops students who try to describe her as one. She describes herself as a person who tried to do the right thing and was not believed, and then spent 11 years carrying the weight of what that meant, and that the course of that experience had taught her 2 things she considered worth passing on. The first was that the right thing in an institution is almost always harder and lonelier than it looks from the outside, and that a person deciding whether to attempt it should go in with clear eyes about both of those costs and decide anyway. The second was that being disbelieved the first time is not the same as being wrong, and that the difference between those 2 things is the most important professional distinction she has ever learnt to make, and the one she most wishes she had understood at 28, sitting across from a chief of medicine who folded her concern back into her hands as politely and as finally as a door being closed. She ends every seminar the same way. She tells the students that the people in the beds are counting on them to notice, and that noticing is not enough, and that saying so is not enough, and that being told they are wrong is not evidence that they are wrong, and that the obligation does not end where the institutional resistance begins. And then she asks them, by show of hands, how many of them have ever been in a situation at work where they saw something that felt wrong and did not say anything because they were afraid of exactly what happened to her. And every semester the same thing happens. Almost every hand in the room goes up. The seminar continues to run, the hands continue to go up. That is, for now, where this story ends, not with a verdict or a sentence or a bench removed from a parking lot, but with a room full of people being asked whether they have ever been silent about something that deserved to be said, and with the honest, uncomfortable, necessary answer that rises from the room every time the question is put. It rises because it is true. It rises because every institution contains that silence at its edges and sometimes at its center, and because the work of reducing it is permanent and unglamorous and is done mostly by people like Patricia Odom, who are not particularly extraordinary, except in this they noticed and they said so, and when they were told they were wrong, they remembered for 11 years that they were not.